is, because we talk about that like, because it's something that we use shorthand for. It's a big deal for us, but when we're defending against sexual harassment lawsuits. But the affirmative defense that we talk about, that a harassment policy helps you defend against, is that if you have an employee who claims they were subjected to a hostile work environment, that they had either a supervisor or a coworker who may engaged in sexual harassment that was severe and pervasive, and all of the things that qualify as sexual harassment. If there has been no tangible job action taken, they haven't been demoted, they haven't been fired, it's just what they're complaining about is a hostile work environment, I've been subjected to a hostile work environment, then the courts recognize that employers can only remedy the things that they know about, and that employers should have the opportunity to correct those things. And so in a couple of landmark sexual harassment cases from the late 90s, the U.S. Supreme Court said that an employer has an affirmative defense that if they can show that they had an appropriate remedial process and that the employer failed to utilize that process, then the employer is not vicariously liable for the harassment that the supervisor or the coworker engaged in that didn't lead to a tangible employment action. So employers are not on the hook for sexual harassment that they don't know about if they provided an appropriate remedial process and the employee unreasonably failed to use that process. That's why it's so important to have a complaint procedure that the employees know about and that they are encouraged to use. And because what happens frequently is that an employer gets hit with a sexual harassment lawsuit, and it says, John Doe's been harassing me for 2 years, and the employer says, I never knew anything about it. They never said anything to me about that. But you've got an affirmative defense against that. You're not liable for John Doe's lechery if you can show I had a policy in place, they knew about that policy, and they failed to make a complaint to me. But it starts with the policy, having a policy in place, because the courts, the 10th Circuit has recognized that if you have a sexual harassment policy in place with an appropriate remedial measure, that you, and then that protects you against harassment type of claims, against vicarious liability. And so I think it's probably the most important policy that you have, because it provides you the best protection against a very common type of claim.
So what would you say is best for documentation if you have a process in place and you've investigated? Do you want that employee that brought up the issue of harassment to sign something off that it's been remedied, or how should that be taken care of? What sort of do you need documentation?
Yeah, so you should document the process. So you get an employee complaint. First of all, I would say that you shouldn't have in your policy that it has to be a written complaint. If you have a notice, actual notice, because they come and talk to you, and sometimes people who are being harassed don't want to make a written complaint or don't want to do anything, but if they come to you and you have actual notice and you institute an investigation, I would document the steps in that investigation, the steps that you took, who you talked to, who you interviewed, what they said. I would prepare a report about what you're going to do, and then it's up to the employer to take appropriate remedial action. That doesn't mean that you have to, if you find that sexual harassment has occurred, that you have to fire the employee. You just have to be able to show that you took action that was reasonably calculated to prevent further harassment. So in some circumstances it may be a written warning, it may be a suspension, could be a termination, but it just has to be something that's reasonably calculated to prevent further harassment. Obviously you want to document the disciplinary action that's taken against the employee, and then I don't think that you have to necessarily tell the complainant what disciplinary action you took. I mean, you don't have to say, I suspended this person for a week or whatever. I mean, they'll frequently know. I mean, it's just how it works in workplaces. But you don't have to tell them what you did, but you do tell them that we've took action to prevent further harassment. If you experience any further harassment, we encourage you to bring that to our attention, and we will address that again. And if you feel, and I would also include in that notice the reminder of the anti-retaliation provision, that we're not going to retaliate against you for bringing in any further complaints. And I provide that notice and document that's been provided to the employee. Does that answer your question? That's how I would generally approach that type of issue. Talk a little bit about leave policies. Leave policies are something that you kind of want to address in as much detail as you can. A couple of things to keep in mind. Just in terms of sick leave and vacation leave, you want to address what are the limits, how is that going to be accrued, and then I think a big thing that you want to make sure to address is that going to be paid out upon the employee leaving, or are there going to be some sort of strings to how, if we pay that out, if the employee leaves and they have accrued vacation. You want to make sure that you consider whether you want to have caps on how much leave they can accrue. But the state law would say that if you've accrued vacation and you have a reasonable expectation that it's going to be paid out when you leave, then you may have a contract claim to be paid out that leave. And so, but the employer controls that. You can put in your handbook that accrued but unused leave that you have at the time of your employment is forfeited. That you're not going to be paid out, but you want to be explicit about how you approach that. And employers have a wide range of how they do that. I mean, a lot of times employers do decide they want to pay it out, in part because they don't want the situation where employees, start just excessively using their leave before they leave. They sort of soft resignation, so to speak. And to give them encouragement to help train their replacement or things like that. So, but you want to address that in your leave policies. If you have specific, you may want to address how vacations are going to be scheduled, or leave requests. If you're going to have a requirement that leave requests have to be in by a certain time, you want to address that. You may address holiday leave. What are the holidays that we recognize? Are we going to have holiday pay? That's something that you might address in a holiday leave policy. If we require you to work on a holiday, are we going to pay you some sort of premium to do that? Or are we going to give you another day off? I think that the point of having clearly defined leave policies is that it avoids disputes with employees, and it gives, again, supervisors some guidance on how to handle leave requests. Leah touched on this a little bit. The family and medical leave is I won't say I think a lot of employers think of it as complicated, and maybe it is to some degree.